direct the Honorable Deputy Registrar of this division to transmit a copy of this ruling to the Honorable. Before we conclude, the bench wishes to once again emphasize its unwavering commitment to objective neutrality. We assure all parties that the right to a fair hearing remains fully guaranteed. Bench acting with fidelity to its oath of office and in strict adherence to the dictates of the Constitution remains resolutely committed to the fair and just resolution of the issues before it. Finally, the application dated 22nd of October 2024 is disallowed with cause in the course. Leave to appeal is hereby granted, such that copies of these proceedings and rulings shall be available upon payment of the requisite fees as may be.
Much obliged, my lord.
On behalf of the petitioners, we have listened to the ruling. We have got no problem with the visibility of it one way or the other. We leave it to our clients, the decision on whether or not we will approve the ruling, largely because of a number of instances where words have been put into the mouths of the petitioners that were never uttered. That as it may, I believe since we received some communications from the Deputy Registrar, and there were certain other pending matters in the files that were under considerations, we shall await the directions of the court before, from the petitioner's point of view, we can say one or two things. I do not know whether a business as Milimani Senior and from which has anything to add.
My lords, your leadership, we appreciate this honorable court of his own volition granted leave to appeal. Speaking for myself, obviously the decision is that of the client. I will be advising the client. It is the client to make the final decision. But in fairness to me as counsel and other counsel on this bench, I will certainly be seeking to persuade my client to appeal. One issue of accusing counsel to have been talking to the gallery, that is not something that should be left on the record of this. It's damaging to counsel, and that is an issue that definitely needs to be taken out of the record of this by the court. It was a very unfair decision.
Yes, of course, on behalf of the respondents, we thank you for the timely nature, delivery of that ruling to allow this matter. We note that you support that. The respondents support fair resolution of this dispute in accordance with the law. Therefore, we now propose the right. Having said that, however, and in reference to my learned friend, who has alluded to other petitions pending before court, it is the respondent's position that we should exhaust all matters today relating to the matter that has been called out by the legal assistant. I apologize to the lady, so that we may exhaust that, after which the court will give direction any other matter, maybe before you or maybe anticipate. Thank
My Lord, my lady, on behalf of the National Assembly, I wish to express our gratitude for the clear ruling that the court has given this afternoon. Ruling has dealt conclusively, not just with the matters that were contained in the application that was hurriedly filed and responded to yesterday afternoon, but indeed some of the other peripheral issues that the petitioners unfortunately took a lot of court time yesterday. My lords, my ladies, the National Assembly has filed an application dated the 18th of October 2024. And I believe that application was referred to in the ruling a few moments ago. That application, subsequent to the ruling that you have just delivered, I submit is the next issue that the court should deal with. Just to put it on record, my lord, that we are ready to proceed that application this afternoon. Members of the court will recall that last week on Tuesday, 15th of this month, and now are not very different to this, when it suited the petitioner to have their application for conservatory orders heard, they insisted on it being heard. And we request that the agency in this matter remaining and having been noted by the court, we proceed with the hearing of that application, which has been fully responded to immediately after.
My lords and your ladyship, further to that, for Senate, I wish to state, my lords and your ladyship, that unlike willing to argue the application in a record 30 minutes. Yes, the application ended 18th October 2024. We will only ask for 30 minutes to exhaust our application. Dive straight into constitutional principles, we will not take much time. Respondents can have as much time. This matter can be. Lord, the speaker has talked about the gallery. Parliamentary Senior Council. So on that side, it was apparent that they were not just addressing. They were addressing other
Lord,
matters.
do we need to engage? Do we need to engage in arguments on that? I was answering.
I will withdraw that. My lord, we are ready to proceed.
Stop exciting.
I will withdraw the remark that the petitioners are addressing the public gallery today.
My Lord, my Lord, with your permission, yesterday we were barred from being part of these proceedings. We have seen communication that we are now legally here. We have stopped mourning. Could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you. Our files, there is petition 5E570, E550, E541, E572 that are supposed to be before. That we complained to the CJ in the morning, and the CJ has directed we appear here and be part of this mosaic. Kindly let us be part of it.
Your Lordship, equally, I rise as the advocate appearing in E509 and associate myself with the submissions made by my learned senior counsel, Paul Moite, and the ones made by my learned friend, Senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated and now E565 consolidated. And we have been issued the notice that my friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My Lord, may please, this is most. We are all counsel of some reasonable papers. We all appreciate some of them here are very senior advocates, very senior. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expectations disposal.
Your Lordship, my Lord, if I may, my Lord. There are matters that you have certified as ID and that you have identified as being ID. And I say this with a very heavy heart. My learned colleagues for the petition have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as ID. There are several other matters that have applications that perhaps have not been certified as ID. Perhaps Your Lordship may be kind enough to deal with those ID applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Your Lordship, the counsel on this side they have, counsel on that side appears to be taking the whole of the please,
Let's be.
my Lord, I'm asking for equity of more time to counsel on this side to address the.
Let me stand and state, my Lord. Just a minute. My Lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling, the question that they wanted was the application for the validity plus the issue to do with the recusal being merged together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issue after the issue of the validity of the bench has been disposed of are the 3 pending. Are they 3? Actually, I'm not about 3 applications for recusal. Those are preliminary issues, and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my Lord, that is important to be noted. Yes, the consolidated file that is before you has that application for recusal. That's what my learned is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition had as of yesterday. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitution, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number one. Issue number two, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimotho, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situation where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the enforcement of that.
I just wanted to highlight the content of the notice which you received.
I think you have to talk about the decision.
Yeah, and your lordship, your lordship, the question that
I will
was posed.
talk about that.
You have your permission to address it?
The judge is
Oh, sorry, I apologize. I apologize.
You will appreciate that when we retired yesterday, we received therefore, don't think you are the only person in the matters. So you wait for God to give direction, then you trust God. Let us mention this point. Yeah. Let's mention this point. We have two cohorts which have been first cohort was the challenge the processes in Parliament. Yes. During that time, this bench, six petitions. The lead petition being 522. Is that correct? That petition, number 522 from 2024, is the lead file in the petitions which were filed for the finalization of the matter. Then, after the proceedings in the Senate, other petitions were filed. We consolidated all those petitions. So we have two running parallel petitions before the proceedings and after the Senate. You will remember that petition number 522 was listed because of need to know, because I know it was cutting it. And they just call it because all of you here, so that if there's anything you want to say on the petitions, so that's out 522 here for a mention. That is the mention that we say since parties are not here, some of the parties were even asking for it. But the other petitions we mentioned are specific. We wanted to find out the way forward. These petitions, but so these are petitions number. Let's mention petition number 570 from AD.
Yes. My Lord, in this petition, this one was filed by the law firm of, I believe, Mutembei and Maret, Mutembei, Bishoro, and Company Advocates. I am aware of this petition for the simple reason that he had requested me that when it comes to the hearing, I appear alongside him. Mr. Mutembei Marete. My Lord, the parties are many, starting with the first respondent, I think is President Ruto. Regarding Gachagua'S is the second respondent, and there are others. My Lord, for purposes of this petition, it was filed on Friday, and by Judge Mamuye, referred it to the Honorable Chief Justice, and we expected it to be coming tomorrow on Thursday. My Lord, Mr. Mutembei was not served with this particular notice that is before you. Yes. 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 Yes, waiting for them here. So that, my Lord, in that case, what I would ask the court, and for the additional reason that I am aware that in that matter, the notice of motion is seeking a 5-judge bench, and particularly for the reason that this is an application by the citizens of Central Kenya who says, like in the year 2013, that their rights, not just regarding Gachagua, have been affected adversely by the impeachment of the Deputy President Gachagua, and therefore I would ask that this matter do come tomorrow so that the issue on that issues of empanelment and in the presence of Mr. Mutembei can be dealt with. Because now that it is obvious that even the direct, like the advocates who filed the case are not here, it would only be fair that there is another mention where they can also be there. Actually, we didn't even have the file. We are just looking at it from our record. But that is the position as far as 570 is concerned. With a specific application for a 5-judge bench.